Everyone. My name is Theo Liebman. I'm the Executive Director of Hofstra's Freedman Institute for the Study of Legal Ethics, and I'm very pleased to welcome you to today's panel on lawyer shaming, lawyer independence, and bad clients. Today, the panel is going to be looking at the question of how far should we go in holding lawyers accountable for the causes and clients that they represent? That's a question that has arisen again and again, as long as there have been lawyers. And as far back in US legal history, at least as the criticism of John Adams for representing British soldiers after the 1770 Boston Massacre. Maybe due to social media, although we tend to blame that for lots of things, but it does feel as though the issue of criticizing lawyers has intensified in recent years. Lawyers and law firms have been excoriated by the public, by fellow members of the bar, and occasionally sanctioned by the court for issues as varied as challenging the validity of the 2020 elections, defending Harvey Weinstein, representing fossil fuel companies, and representing governments in human rights issues, such as efforts to repress free speech, or right here in the US, government lawyers who defended ICE family separation policies. There's a lot at stake in this debate. On the one hand, we generally believe lawyers are independent counselors and advocates and should not be considered supporters of the client's causes just because they're representing them. In fact, the ethical rules even say that. So why should they be held accountable for those clients and causes? On the other hand, as Monroe Freedman, who this institute is named for, observed when his good friend, the ethicist and lawyer Michael Tiger, took on the defense of John Demjanjuk, a concentration camp guard in Treblinka, he asked his friend, of course he's entitled to a lawyer, but does it have to be you? So to sort through some of these ethical principles and questions here, we're joined by a terrific panel. I'm going to be keeping the intros of them brief to ensure that we have a lot of time to hear what they have to say, and also for some Q&A at the end. First, I want to welcome Camila Bustos, who is a visiting assistant professor of human rights at Trinity College. She's a law clerk at Connecticut Supreme Court. And while in law school, she was a co-founder of Law Students for Climate Accountability. Our second panelist is Julian Koo, who is the Maurice A. Dean Distinguished Professor in Constitutional Law here at Hofstra. He has written extensively and testified before Congress, among other things, on China's relationship to international law. And finally, we welcome Brad Wendell, the Edwin Woodruff Professor of Law at Cornell Law School. He's an ethicist and prolific author whose most recent article is actually a deep dive on this issue, the ethics and morals of lawyer shaming. I'm probably going to stop the panel discussion after about 45 or 50 minutes to allow plenty of time for questions and answers from the audience. If you have a question, you can put it in the chat at any time, even though I won't be getting to it until about 45 or 50 minutes from now. So feel free to put stuff in there. I will get to as many questions as I can. All right. Camila, why don't we start with you? Maybe you can lay the groundwork a little for our discussion by telling us a little about Law Students for Climate Accountability, its goals, its strategy, and whether it's been successful, if that's even something that can be measured. And I'll put a link in the chat to the Lawyers Students for Accountability, the Climate Accountability website.
Great, thanks so much. Hi everyone, and thanks again for the invitation and to the organizers for putting the event together. So I'm Camila. I'm one of the co-founders of Law Students for Climate Accountability, which is a relatively new organization. It started in late 2020, I think as a very organic effort, growing from the frustration that many young recent grads and law students feel with regards to the role of lawyers with respect to the climate crisis. So I think for a lot of us coming into law school, we came in with the desire to fight for climate justice. We knew that we wanted to do that, during and after we graduated. And if not primarily to work on climate, that we at least think it's like a generational threat, an existential threat in many ways. And so when we got to law school, we realized that law schools are not always prepared to talk about the climate crisis or like the role of lawyers and the ethical obligations that we may have, and that there's this pipeline between law schools and law firms, some of which have a particular role in, we think, contributing to the climate crisis through their transactional litigation and lobbying work. So what we did was we did a climate scorecard, which I think you might be able to find on our website. There's a 2020 version and a 2021 version that essentially gives a score to the top law firms. This is the Vault list of firms based on each of those categories. So transactions, lobbying, and litigation. That gives them a composite score and sort of grades them like from A to F. And not surprisingly, most law firms, big law firms, are contributing heavily to the climate crisis through the representation of fossil fuel firms or companies. And so that's kind of where it came from. And I think it began more as a nerdy exercise by a few of us who had extra time in our hands. And it's now a national organization with board members from across dozens of schools, law schools in the US, again, trying to push for more accountability in the legal sector.
Terrific, thanks. And I'm going to briefly just share the screen so people can see what the scorecard looks like. So climate scores for the Vault 100 law firms. If you want to see whether a law firm you're interested in is on this list, you can go to the link that was provided in the chat. I have to say the curve on this, Camila, is a lot more devastating than any curves I law firms seem to mostly have D's and F's there. Okay, Julian, let me turn to you next. So maybe you can kind of give us another example of sort of holding lawyers accountable for their clients. And in particular, maybe you can describe what happened this past fall with the big law firm, U.S. and international law firm Mayer Brown was representing Hong Kong University in their efforts to have torn down a long-standing statue that memorialized the massacre in Tiananmen Square in 1989. And there was some lawyer shaming there, and perhaps was effective, perhaps not. Can you give us a little background on that?
All right, so thanks. Thank you, Teo, for inviting me to sort of join this. This is not, legal ethics is not something I've, have a lot of knowledge about, frankly. I'll admit, and Camila might know, you guys might know, I vaguely remember taking something at law school about it, but it wasn't a whole lot, I feel like. So I'm not going to talk too much about, I don't want to claim too much knowledge on legal ethics, although I do think that there's something interesting in sort of what's going on. One of my areas of research is international law, but more broadly than that, sort of the intersection between domestic spheres, domestic laws, and international practice. And one of the areas I'm fascinated by, both in my professional experience and also just in my research and teaching, is sort of the interactions between private individuals, private businesses operating abroad, and sort of the challenges, legal and ethical, that pop up in that context. And so what I want to sort of suggest is that this has always been an issue. Like, if you are a so-called international lawyer, you're always going to be operating in a different legal and moral sphere when you operate a cross-border practice. This has always been the case, even when this. But what's new, I think, is that there's been a tremendous growth in commercial activity across borders, right, the last 50 years, and certainly the last 20 years. And then related to that, there's been enormous growth in law firms providing advice in the commercial context for international activities, for activities that businesses and their clients are doing in other countries, for foreign clients, for clients in other countries, and for activities that occur outside the reach of, say, US law, and maybe even US ethical rules. And so one of the things that's challenging is that businesses are doing these things, and maybe in a world that's less turbulent than ours, we would not find this to be a problem. But we see now that this is harder to pull off this balance where I'm just doing business, I'm just providing business advice, and I don't have to worry about the ethical obligations or the ethical impact or the moral impact of what my clients are doing in these countries. And so, and again, it might be, well, I just don't do business or I don't advise clients in these countries. But what I'm fascinated by is that China has become a difficult thing, because China is deeply embedded in the US economy, and US clients and businesses and law firms, especially large law firms, have a huge connection and gigantic relationships with the Chinese market, the Chinese legal market, but also the Chinese business market. And so it's harder to balance these sorts of concerns as relations and concerns about China have increased dramatically here in the States in the last few years. So to get to the example that Professor Liebman was mentioning, there's been a bigger question about, well, to what degree should US businesses be doing business in China given the very severe and serious human rights concerns that have been raised by the US government and other very credible sources? And then, like, for instance, should Airbnb be operating in an area where the US government has said a forced labor and genocide is occurring? And that's a interesting problem. What about Airbnb's lawyers? Should they be providing advice for Airbnb on how to operate in a country where an alleged genocide is going on? And so a related issue to that would be the example from this past fall. Mayer Brown, which is one of the largest law firms, I noticed it gets an F on Camilla's list. So they're not great anyways, I guess. But they are one of the largest law firms in the country, Chicago-based. They have a huge international practice as well. And last fall, they in a routine matter, provided legal advice to one of their clients in Hong Kong University, about the removal of a statue that commemorates the 1989 Tiananmen Massacre. Now, why does this matter? It's a small matter. And it was essentially a real estate sort of legal advice, property law legal advice question. But this statue has become a huge symbol of what's going on in Hong Kong, about Chinese government's decision to eliminate slowly and methodically any sort of individual freedom, political freedom, and academic freedom in Hong Kong through its new measures. And this statue, which was a symbol of how Hong Kong is different from mainland China, that you can talk about the 1989 massacre and not be punished for it in Hong Kong. This was a big deal. This is one of the reasons why Hong Kong is different than China. And the removal of this statue and the demand that pro-democracy sort of NGOs in Hong Kong remove the statue seemed a pretty dramatic blow to this sort of whatever's left of the individual freedoms and rights that were supposedly guaranteed when Hong Kong returned to China. So all Mayer Brown did was send a letter demanding the statue be removed under its honest letterhead. Big deal. It's not itself doing anything wrong, but it sparked global outrage. It sparked Twitter, more than just a Twitter campaign, but a letter from global human rights organizations demanding Mayer Brown withdraw its representation. And what's amazing in this case is that they did. Mayer Brown issued a quick statement saying, originally they said, well, we're just representing a client on a real estate matter. And then a week later, or days later, they just said, we are no longer representing this client on this matter. We withdraw, right? Now, it didn't make a difference. They removed the statue anyways. Freedom suppression continues in Hong Kong. But what's fascinating is that I think you would have imagined 20 years ago, Mayer Brown would say, look, we're just providing, we didn't do anything wrong here. We're just providing legal advice. We didn't breach any laws or ethical rules. But this time they backed off under pressure from public pressure here in the States. And this is, I think, an interesting question is, should law firms in this context really be concerned about their reputation and who they represent, even for matters that are perfectly normal and routine? And I think increasingly this is going to be harder for law firms to, especially these big law firms when they represent clients in commercial matters, where they run into the buzzsaw of various sort of international conflicts. It's going to be harder and harder to do this. It's a challenge. I think for me, I'm just instinctively, like most people who go to law school and become a lawyer, I'm not excited about shaming lawyers for their clients, right? This is the whole point. But maybe in this context where law firms and their clients are being shamed on ethical and moral grounds, the lawyers themselves should not escape accountability for their decisions as well. So especially given some of the egregious things that are being accused. I'll just note another one of the firms that got an F on Camilla's list, Sidley & Austin, recently announced that they engaged in a $500,000 lobbying campaign last month in fees for a Chinese tech company that's accused of building out the surveillance network that is enabling the suppression of the Muslim minority in Xinjiang, which is part of the alleged genocide and crimes against humanity. So this is something where Sidley & Austin is choosing to take on, for substantial sums, a client that's been sanctioned by the US government for other reasons. And it's legal for them to do so, but should they face any blowback for their decision to take on this? I think what's different is that the normal instinctive, this is just lawyering, it's okay, is facing a bigger blowback. In this case, it's not even just from one side or one activist group, it's a broad-based concern. So we'll see more and more of these challenges, especially for big commercial law firms acting in China and other countries like it. So that's a great example. I look forward to hearing from Professor Wendell, who's thought about this in a much more rigorous way than I have. But I do think it's a fascinating example of something we're going to be heading toward. I'll just say one more thing before I turn it over to him. Maybe one factor here is Mayor Brown and these other law firms issuing very public statements of their values, and including deep moral commitments to non-discrimination after the George Floyd incident, or to their pro bono activities in favor of for particular groups. And that maybe people will, why do you care so much about non-discrimination unless it's against Muslims in China? In which case I'll take the money. In fact, I prefer the money instead of, not only do I not care about Muslims being forced labor and sterilized in China because they're Muslim, I actually want to be paid to help. That does seem a bit of a disconnect, and maybe they should be held more accountable than they have been without just saying, wow, they're just lawyers. So I look forward to hearing what everyone else thinks. Thanks.
Thanks a lot, Julian. So Brad, I think it's been teed up for you now a number of examples of lawyer shaming, criticizing lawyers, holding lawyers accountable. So maybe you can begin our discussion of what it means for lawyers to be held accountable, to whom they should be accountable, if anyone, beyond their own clients. And I know you've written a paper on this, and I'm going to put a link in the chat for anyone who wants to read the full paper, which is excellent. Take it away.
Yeah, thanks, Theo. That's a great question. And let me just start with a little framing thing, which inevitably comes up whenever we talk about legal ethics. What are we talking about here? Are we talking about the rules of professional conduct and the law of lawyering, or something else? And I happen to work in the rules of professional conduct area. I teach it. It's a wonderful area, but I'm also a theorist and a philosopher and a theoretical ethicist. And so what I want to talk about really is more the latter than the former. So there are some ethics rules on this. There's a rule the rule on lawyer-client decision-making, Rule 1.2 in the model rules, has a weird little provision, 1.2b, which says a lawyer's representation of a client does not constitute an endorsement of the client's political, social, economic, etc. views. Now, this is odd because most of the provisions in the model rules are duties. They say a lawyer shall do this or may do this. This just kind of seems to say lawyers aren't accountable for the clients they represent or the client's objectives. And it's kind of an odd rule. Who is it addressed to? But again, I'm not so much concerned with that. I want to talk more about critical morality, the standpoint from which people outside the profession criticize lawyers. Sometimes theorists talk about this in terms of role morality. So Julian had a really nice phrase, which I wrote down. It's just lawyering, it's okay. This is kind of the standard claim of role morality, which is that many social roles, the legal profession, the medical profession, the military, whatever, have characteristic obligations and duties associated with them, and therefore stand in a different kind of relationship to third parties than ordinary morality would make us normally accountable for. So we keep using this word accountability. Camila started with that. What does that mean? So for me in moral philosophy, accountability simply means having to answer a justified demand from someone else for an explanation for your actions that affect their interest in some way. So I always use this example from Stephen Darwall. Suppose you step on someone's toe and it hurts, and they say, "Ouch, you're stepping on my toe." That's a demand for accountability. That's all that means. And in response to that demand, you can either get off this person's toe or offer some explanation like, "Oh, I'm sorry, it's the subway, it's crowded, I didn't mean to do that, my bad." But you're offering a justification or an excuse, or you're refraining from the conduct. That's all a demand for accountability means. It reflects the relational nature of morality. It reflects the fact that when we act in ways that affect the interests of others, we owe them an explanation. Now, the great question is, why the heck do we think the legal profession is accountable to the public as a whole? Well, the theory of professionalism is that we enjoy this valuable monopoly over the provision of certain kinds of services in exchange for an undertaking to practice our craft in the public interest. And we sometimes shorthand that by saying we're officers of the court, we're regulated by courts, and it's true. But there is this, part of professional ideology is that we have an implied obligation to practice our craft in the public interest. And this is where this demand for accountability comes from. Now, one of the things I wanted to really make stick in my paper, and if nothing else sticks from the paper, I really want this to land, and that is that the standard lawyer move of saying, "You can't criticize us," is not valid. You can criticize us. What is also the case, however, is most of the time lawyers have a pretty good justification. And that's particularly true in the criminal context. In some ways, we make a mistake by overgeneralizing from the context of criminal defense representation, where the normative arguments for why lawyers can represent clients accused of doing terrible things are pretty well established and pretty good. They're arguments related to due process, the importance of individual autonomy, protecting people against the power of the state, checking the power of the state, treating people with dignity. These are all pretty good arguments. They turn out to be pretty good ethical vindications of the demand for accountability. So the criminal defense example doesn't show that lawyers aren't accountable or that you can't criticize lawyers. It's just that in most cases, lawyers have a pretty good defense. Now, in the cases raised by Camilla and Julian, the question is, do big law firms have a good defense for representing fossil fuel companies, the government of Hong Kong in response to the demand to remove the Tiananmen statue, and those sorts of things? All I'm saying is that lawyers have to, and I think Julian put this really well, dig deep into their values and give that explanation, or be prepared to give that explanation. And there may be some good reason for doing this, having to do with the function of the law in enabling the orderly resolution of conflict and things like that. I've written a whole book about this. So I think that actually in most cases, the law firms do have a good defense, but requiring them to go and dig deep may really help motivate ethical lawyering. And I'll give one quick example and then I'll shut up. This is something I talk about in my paper, and I love this example. There was a reparations action begun in the United States for victims of the Holocaust whose gold had been looted by the Nazis and kept in Swiss banks. And the reparations action was against Credit Suisse and other Swiss banks. They immediately lined up representation from all these big law firms. And one of the law firms was Cravath, and they were representing Credit Suisse, and the associates in the firm rebelled. They said, "Whoa, what are we doing? We're representing Credit Suisse in an action on the other side of the victims of the Holocaust. What are we doing?" And the partners responded first in a kind of weak way and then in a stronger way to the associates' memo. And what ended up happening as a result of this internal debate within Cravath was that the firm went to the client, to Credit Suisse, and said, "Look, we'll represent you provided your goal is to accomplish an orderly disposition of looted assets and to kind of work within the process. But we will in no event deny the basic justice of these claims. If you're not okay with that, find another law firm." And Credit Suisse said, "No, that's fine." But that initial conversation about the parameters of the representation were motivated by a demand for accountability. So that's all this idea of accountability is. That's all this idea of justified criticism of lawyers acting in a professional role. It's all that's about. I'm not saying that lawyers have to suddenly start divesting themselves from clients. I'm just saying be prepared to give an account of yourself in ethical terms, not just the rules, but in critical moral terms for why you do what you do. And that can end up motivating a lot of better practice by lawyers in the long run. So that's the point of the paper. That's where I'm coming from as a philosopher and a lawyer. So I'm basically with Camilla and Julian on this.
Thanks a lot, Brad. But at the risk of making you not with Camila and Julian on this, Camila, is that enough for you that these law firms that represent these polluters dig really deep and think about why they're representing companies and lobbying on their behalf in terms of minimizing laws that can reduce climate change and pollution? Is it enough for you that they really think about it? Or aren't you trying to get them to drop those clients so that those corporations are shamed into changing their ways?
So that's a great question, controversial. So I love it. But I feel like you've laid down a spectrum, right? I feel like there's easy asks or easier asks, and then I think at the end of it, it's like drop your representation, which is clearly, if they did today, would be in violation of their ethical obligations to their clients. So that's not what I'm saying, but I will say that, at least personally, and I think LCA stands for this as well, is that it's not enough to just question or feel bad or think critically. I think that's the first step. And I think that should be followed by action. And I think so what we're asking really is a couple of things. Is for firms to stop pointing to recycling programs and LED bulbs, in their offices as enough, as if that was going to, be a sufficient commitment to tackle the climate crisis. To stop pointing at pro bono as an excuse or a moral, absolution of what they're doing bad. I think sometimes law firms want to have it both ways, right? They want to point to things like representing, immigrant rights movements or victims of police brutality, and at the same time, they want to continue representing companies whose business is to destroy the planet, essentially. Because I think one thing that I may not have made clear is that for us, the fossil fuel industry is different than other big industries in many ways. It's similar, sure, like many other industries, it has carried environmental and human rights violations across the world. But the fossil fuel industry is different in that its business is in direct contradiction to our existence on this planet. And I think that's where, for us, the call for accountability can be made so strongly for that sector. So, while I have no illusions that tomorrow all of these firms would drop their clients, I do think that there's like an importance in the calling and in the pressuring, really, because we know that they don't have to represent these clients. They have a choice. And at the same time, I think that they will use sometimes some of those arguments that Professor Wendell raised about the criminal defendant context. Everyone deserves a lawyer. We're just merely providing a service. We're lending a service to defendants here. And the reality is that, while that may be true in like criminal context in an adversarial system, when we're talking about like facilitating transactional work, when we're talking about lobbying in DC for like, against like carbon taxes and environmental, like unprogressive policy in the environmental regulation, that's just not true and like not applicable. So I think it's important for us to like really think critically about some of the arguments that some of the partners and associates at these firms will make with regards to the representation of the fossil fuel industry. And I think I'll end with that.
So Julian, let me ask you, where do you fall on this idea of whether a proper goal of lawyer shaming isn't to cause questioning, but to actually get lawyers to stop representing clients? Do you think that is an appropriate goal for lawyer shaming? And if so, is there a line or some criteria we can use to decide when that's an appropriate goal and when not? That's a big question. A big question. And Brad and Camille, I'll give you guys a chance on that one too.
Yeah, no, this is the crux of the matter. I really like Brad's formulation, which I think is very intuitive. It makes a lot of sense, right? I mean, I think it helps us unpack that not every situation is the same, right? It depends on this is a very lawyer thing to say. Depends on the facts of the case, right? I mean, in representing a criminal defendant, and it might be very different than choosing to lobby on behalf of a fossil fuel company on a particular piece of legislation that is particularly bad versus, say, lobbying on some compromise legislation that would work out some deal where we, so in other words, the context seems to matter. And so that's, I think, that's why it's hard to come up with a generalizable rule or a universal rule that would apply in all circumstances. I think Brad's paper sets out this, I think, this framework. It's not true that you cannot criticize a lawyer. Like that should be that just because you're a lawyer, you should escape accountability. I think that's an important thing to remember, because that's often the defense of, it's a lawyer, it's different, right? At the same time, there's no universal. I can't myself generalize, even in this context, for the Chinese context, what the universal rule should be in this context. I think we can draw a line between criminal defense and transactional, right, representations, or maybe political lobbying, right? And I do think that, for me, I'm attracted also by the idea of forcing a law firm to commit to uphold the standards it demands it sets forth for itself, like a generalizable position against non-discrimination, right? And a deep commitment to sort of racial diversity and non-discrimination, equal treatment, probably should preclude some representations then, which are transactional or something like that. So again, I really do think Sidley Austin is more at the opposite end of the spectrum. I think Mary Brown's kind of in the middle, because they're representing someone. I think it's a problem, but it's not. You can justify. It's a good example. You could justify it because the client needs advice. They might just do it anyways. Maybe we can at least help them understand what their rights are, and maybe we can work out some compromise, right? But in the Sidley Austin context, political lobbying against restrictions on the sales of a product that would be used for serious political repression, that seems like quite another end of the spectrum. You might have a harder time, to use Brad's framework, justifying that, right? Well, what is the justification? Why do these people need political lobbyists for this particular purpose, right? And so that's why I do find it hard to come. So far, I've only been able to come up with, and I do think what will happen is, if Camilla's sort of campaigns and like them are similar, we'll just see law firms carving themselves up into smaller and smaller pieces and say, okay, these people are the climate people, and then or we'll see the climate. There'll be the oil. We represent fossil fuel companies. There'll be like fewer law firms in that context, and then everyone else runs in the other direction, right? And the same thing might happen. And so I think bigger law firms will have a harder time doing this, because they have these big values, they have these big images and reputations, and then they have to figure out how to deal with that because they have so many clients. If you had a small law firm, you can say, well, it's only 5 of us, we all agree fossil fuels are fine, then that's it, right? We don't have to worry about this anymore. So you might see segmentation in the law firm market. It's the big law firms, I think, that are most vulnerable to these sorts of campaigns.
And Brad, do you think I made an unfair distinction between what you were saying about it's okay to make lawyers think really hard about what they're doing and trying to shame them into dropping clients?
No, I think that's fine. So my wife likes to remind me that, on the TV show The Good Place, this great character, Chidi Anagonye, the moral philosopher, all the other characters said, everybody hates moral philosophers. And the reason for that is that Chidi could never come down on one side. He said, well, on the one hand and on the other hand, and drove others and himself crazy. So I'll go ahead and bite the bullet. I'm going to come down on one side. So this is another book that I wrote called Lawyers' Infidelity to Law. I actually do believe that in many of these cases, there is a justification. So I'm not just saying dig down into your values and kind of, think about it a little bit, but don't do anything meaningful. I'm saying dig down into your values and conclude that what you're doing is justified. And this is where I know Camilla and I are going to completely part ways, because I believe that a lot of the kind of lobbying and transactional work that lawyers do is ethically justified as against this demand for accountability. I made myself a nuisance in the field of legal ethics by disagreeing with the kind of earlier wave of theorists, David Luban, Bill Simon, and others, who say that the ethics in legal ethics, the critical morality in legal ethics, is kind of first order moral values like justice. And my view, which got labeled the second wave of legal ethics with a few other people, Tim Dare from New Zealand, to some extent, Daniel Markovits from Yale takes a similar position, which is to say that the ethical principles in legal ethics are really political values associated with liberal democracy, which have to do with allowing people to resolve conflict and live together in, you know, relative peace, notwithstanding deep and persistent disagreement. And so the legal profession and its ethics has to be understood as kind of a branch of political philosophy. And so this is what I've defended in a lot of writing, and I believe it to be the case. So I think that in a lot of cases, law firms should just, you know, look this in the eye and say, we accept the demand that we provide a justification, and we think we have a justification. You know, sometimes criticism is unfair. Sometimes you just kind of have to deal with it. You know, people don't always like lawyers, and they say nasty things about lawyers. Deal with it. You know, that's just kind of the way it goes. There are lawyer jokes. Now, there is an interesting set of cases, and this is what I think is something theoretically interesting that I want to talk about in a book that I'm working on, and that is there may be cases in which what a lawyer is doing is justified, but there nevertheless is this lingering sense of regret, sometimes called a moral remainder, that may motivate different kinds of action. And Camilla raises a really good question about atonement. You know, what constitutes sufficient moral atonement for wrongdoing? And I think she's right that just pointing to doing a bunch of pro bono work for other clients is not sufficient. But a moral remainder may motivate, this sentiment of regret may motivate, you know, some kind of reform effort, or dealing with the client in a different way, or trying to practice in a more ethical way. But I think the set of remainder cases is smaller than the set of all cases in which lawyers might be criticized. I think in most cases in which lawyers might be criticized, they actually have a sufficient justification. And I recommend my book for that. But you know, if you don't buy that, okay. The important thing is just to tee up this argument and to have a really substantive moral conversation about whether what the lawyer is doing in this case is justified.
Can I ask a question? Since I don't know if I'm allowed to.
Yeah.
Well, I guess the question is, so I'm just curious, Brad, where is that? Is there any case you can think of where the lawyers could not justify themselves in their representation? Like, what's the case where it would cross the line for you? Is it because that would also not be unethical under the professional code of conduct, I guess.
Right. I actually, you know, I thought your Hong Kong case was a good one, or the case of Sidley representing the company that was providing the infrastructure in Western China. I think those are cases in which that crosses the line. It's not, you know, let's just stipulate that doesn't violate any of the rules of professional conduct. Some of the Trump campaign cases, you know, Sidney Powell and people like that is easy because they're just flagrantly violating the rules 6 ways from Sunday. That's an easy case. So, you know, I'll accept your hard framing of this and say, imagine a case in which there's no violation of the rules of professional conduct, but an ethically conscientious person ought to say, I'm not going to do that. I simply refuse. I actually think the early version of the Credit Suisse Cravath thing, where there was some possibility that the bank might fight these claims tooth and nail, that might be an example. But I think the Hong Kong case, where, you know, Mayor Brown says, "Oh, it's just a real estate matter. We're moving a piece of property around." No, you're not. You're taking down this symbol of democracy. That's something where an ethically conscientious person might say, I'm not going to lend my assistance to that. Now, let me just say, this may be why people don't like moral philosophers, there can be disagreement about these cases, right? I don't think that ethics is the kind of thing that compels agreement. So, you know, if I present an argument for why an ethically conscientious person would not participate in that, I don't expect everyone's going to fall into line and say, oh yeah, you're right. There can be reasonable disagreement about ethics. That's just part of the fabric of morality, and that's fine. But I'm willing to bite the bullet and say that's a case in which, if I were the law firm managing partner, I'd say, nope, we're not doing this for ethical reasons, not reducible to the rules of professional conduct, but just what a decent person would lend their assistance to doing.
Brad, just quickly, can you maybe sort of be explicit for a minute on the risks of lawyer shaming, you know, the downsides of too much of, and I know you talk about it in your paper a little bit, of too much cancel culture, et cetera. And then, Camilla, I want to give you a chance to respond to the sort of structure that's been created for when it's okay to say you need to stop representing clients. But
no,
yeah,
that's a good question. And I was a bit breezy in the paper. I said, lots of nasty clients seem to have no problem finding lawyers. Look at Harvey Weinstein. He's got lawyers lined up 10 deep to represent him because he has deep pockets. So I gave a version of this paper as a talk at Cardozo, and my commentator, Echo Yankow, gave a fantastic comment. He said, careful. There are some cases in which clients had trouble finding lawyers because of the criticism. And his example was the Scottsboro boys. Where there was no lawyer south of the Mason-Dixon line who would have represented these guys who were wrongfully accused of rape. And that was, it's an extreme example of cancel culture. People feared for their lives. But lawyers were deterred from representing these clients because of fear of public criticism. That's a great example. The other good example is the Red Scare. The ACLU and other, left-leaning organizations had a hard time finding counsel because they were worried that, McCarthyites would scream about them being communists. And so, I'm not saying this isn't a concern or it's a trivial concern. For the most part, nasty clients, at least with deep pockets, seem to have no problem finding lawyers. But it could be the case that, mob rule or mass hysteria or something like that could lead to deserving clients like the ACLU in the 50s having a hard time finding representation. And, that's really more of a political and social issue than a philosophical, theoretical one. But I do want to acknowledge that those cases exist.
I think you answered like what I was going to say, which is I think it's quite different to compare, politically marginalized group of people versus like the big pockets of the fossil fuel industry. And I think that's why also a lot of our messaging is about, the firms and the industry and not necessarily about the individual choice. And there's a tension, right? Like, as we're talking about collectively as a society, what kind of future we envision, and also individually as lawyers, what are our obligations? And I think there's room for debate, as has been made obvious through this discussion. I feel very differently telling a first gen or low-income student to not go to a firm that represents Exxon, for instance, if they depend economically, on that job to like help their families. That feels very different than telling a legacy student at Yale Law School to not take a fancy job at a Manhattan law firm to represent, some of these firms. So I think that's why it's so context dependent, as Professor Kuh mentioned. Like, I don't think it's, it's like there's no bright line rule, but I do think, as advocates, what we're trying to do, as lawyers and advocates, what we're trying to do is really erode the social license of the fossil fuel to operate. I think what we've seen, in the last decade or so has been this effort, not just from the legal field, but, the banking sector, advertisement industry, to really like unveil and uncover, who is it that's propping fossil fuel companies, many of whom like have decades of deception, right? Like that there's been lawsuits and sort of, massive pushback from the public because many of them replicated the tactics that the tobacco industry pursued, right? So same as tobacco industry for a long time continued to say cigarettes were, healthy or didn't cause cancer. Fossil fuel firms, many of them, Exxon and some of the others, like lied to the public and said that climate change was not real. And that has led arguably to like climate inaction, from the local to the state to the national level. So I think we have to remember who we're talking about. At least from the LSCA perspective, we're talking about particularly egregious actors. But I think that's why I wouldn't, say that that there's a bright line or that the same principles that apply here would apply to other cases. I think each case is a specific, but I think again, what we're trying to do as advocates is really like ask these hard questions, and I think push back against the notion that the practices of this firms can go unquestioned because they're just representing clients. When we know it's much trickier than that. We also know that many of these companies have in-house counsel, right? But they rely on highly trained, highly prestigious firms to defend themselves against counties and municipalities who are suing them for their very deceptive practices, as one example of the many lawsuits against them. So again, I think you have to get really in the details of who is the defendant, what sort of representation is being provided, in what context, and are they choosing to represent, which I think is the case for most of these firms, right? They enter into this retainer contracts, into this representation, knowing kind of who the actor is and what they're doing. So yeah, that's I think why facts are so important.
So I want to come back to the law student piece in a minute, because I think that's it's really interesting how we would advise law students in terms of what this means for careers they pursue and law firms they work with. But Before getting to that, I'm curious to hear from all three of you whether you think any of this is different for lawyers. What I mean by that is in terms of lawyers criticizing other lawyers. Should because most of the people who are zoomed in, but not all, but most are lawyers or law students. And do we have the same level of obligation, duty, or right and privilege to criticize other lawyers for their clients and causes? Do we have more of a duty, or should we be more careful and cautious about criticizing other lawyers? Julian, why don't I start with you, since you're dean, and then Brad and Camila as well.
Well, that's a good question. I mean, I think that, I guess I would think that, I think as Professor Wendell said, we're a profession, right? So I think that generally gives us a higher duty, or a greater duty, I guess, to speak about members of our profession, because we're part of, and so there's both better knowledge, but also we have a responsibility to try to articulate what the values of this profession is or ought to be. The problem is, well, I mean, well, I go on Twitter and read some lawyers, right? We don't really, or read the Trump court cases, right? There's a lot of bad lawyering out there. But that's actually part of the way lawyers have to go out there and speak. Now, I guess what I'm saying is it's not well regulated, and the authorities or the institutions that can speak with credibility as to this is tough. I mean, it's just at some point from the outside, it's just lawyers yelling at lawyers, and who cares? And yet, in theory, I think it's still right that we need to try to articulate in good faith what we think the profession requires. I think there's a lot of bad faith arguments made out there as to what the profession requires. And then there's a lot of good faith disagreements about what the profession requires. And we got to sort of figure out how to get into that realm where we have good faith disagreements, but at least a conversation, and I think a fair amount of consensus about what lawyers should be doing and what the boundaries of professional conduct would be. Because I guess maybe I am an institutionalist now too, being a sort of a bureaucrat, academic bureaucrat. I'm kind of in favor of thinking of law as a profession still, and rather than just. And I'll just note as a footnote, I do teach a class in international business law. And one of the things I try to emphasize to my students is that lawyers actually, you may think lawyers are kind of crude and ruthless and kind of amoral. And then you meet your fellows at the MBA school who have MBAs, right? Right? Who are not bound by norms of professional conduct. And internationally, you might say, oh, well, it's all over, right? Woohoo, I can do anything I want. I'm in Thailand or something, right? And I think lawyers are actually, their job is to be the annoying, no, you can't do that, or no, you still have a violation, or no, the law still requires this, or no, you just shouldn't do this. And so I think there is a benefit, there is some value we're bringing to the broader society by trying to maintain this norm, professional norm.
Yeah, before I get into Brad and Camila on that, let me just make it even more concrete, though. A column which you talk about, Brad, in your paper from Dahlia Lithwick, a legal commentator at Slate, is talking about all of the lawyers who worked in the Trump administration on various extremely, to put it mildly, controversial causes, but things like arguing on behalf of the family separation policy or other policies like that. And what Dahlia Lithwick was arguing is that we shouldn't whitewash those lawyers by all of these big law firms now just hiring these people back, that they should face consequences, and in particular that these law firms shouldn't hire them. So that's a very concrete, not, well, we should all criticize each other and try and uphold, make our morals stronger. This is saying what Dahlia Lithwick was saying is that don't hire these people. And Dahlia is a lawyer, and was saying don't hire these other lawyers. So maybe that context, Brad, as you give your answer to the question.
Yeah, I mean that's a great example. It's a hard-hitting column, and she's very smart, and that was a very good column. And I hope not to give a kind of weak tea answer in response to this, but here goes. First of all, I wanted to say that everything Julian said was bang on, and I completely agree with everything he just said. But let me go a little bit now onto the hiring point, and I'll give an example from an iteration of this before this. This was when there was a lot of criticism of lawyers in the George W. Bush administration for the construction of the war on terror and the enhanced interrogation, in other words, torture program. And there was a round of criticism saying, don't hire Jack Goldsmith. He was at OLC. He's a bad guy. He was part of this. And then he got a job at Harvard, and there was an eruption of furor at Harvard about this. And what Goldsmith did, I think very much to his credit, without disclosing confidential information or classified information, he explained what it is that he did. Now, he subsequently wrote a book, really kind of exonerating himself from the worst abuses. But here's the thing: he was called to account. He gave an account for himself. He provided a justification, and that was found satisfactory by professional peers. And he's now a member of the Harvard Law faculty in good standing and highly respected. So I don't mind the demand for accountability. Dahlia Lithwick was going after Rod Rosenstein. It might be that he has a good account that he can give of himself, and he can say, look, I really did try. Within the limits of my professional role, I tried to put the brakes on this. I tried to make it as humane as possible. Did I resign? No, maybe I should have, but he can show himself to be a decent person and should not be then shunned in the professional community. Now, the interesting thing is imagine this sort of thing now exerting some influence on the decision-making of a lawyer currently in government. They're thinking, am I going to be able to get hired after I do this? Well, they might be thinking, okay, then I better do as much as I can as a decent person would do so I can retrospectively justify what I did. Not just because out of greed and I want to get hired by a big law firm, but because I want my conduct to be able to withstand scrutiny. I don't think it's a bad thing at all. And there are cases in which lawyers' conduct has successfully withstood scrutiny. Now, again, what Julian said, we can disagree in good faith about those cases. And so some of those might look like whitewashing, looking the other way, or whatever. Reasonable people can disagree about whether a case is whitewashing or the lawyer's conduct has withstood scrutiny. That's fine. We can disagree about that. But all I'm saying is that we should have that conversation and require lawyers either in their own head or in public to justify what they're doing to others.
Yeah, of course, you got to be careful, because if you're changing your conduct based on sort of some self-reflection, you do have ethical rules and loyalties to your client, and those can push pretty hard back.
Right, there's my so I mean, I'm trying really hard to establish, in legal ethics, the fiduciary norm. We are agents for principles, and that's a good thing. So I'm very much with you on that. I don't think lawyers should pull their punches because they're afraid of being criticized, provided that they're acting as faithful agents of principles and with serving this fiduciary norm. Totally with you on that. And the point of independence is that lawyers should, what's the line? Represent clients without any fear of criticism or whatever. Yes, and sometimes you just have to get a thick skin and deal with criticism. I'm very much with you on that, and I don't want lawyers to be too nervous about this. But to Julian's point about we are a profession, we have ethical obligations, and look at other occupational groups that don't do so well. We do have a standard of ethical conduct to adhere to, and if that means sometimes pushing back on clients, that's another kind of professional independence. Bob Gordon, one of my favorite papers in the whole field is Bob Gordon's paper, Independence of Lawyers. And he says one sense of independence that really matters is independence from powerful clients, and pushing back on powerful clients and saying, no, you simply can't do that. That's also an aspect of professional independence.
We're going to get to questions in 1 second, but Camila, and I know you can answer the general question, but I have a specific question that maybe you can answer as well, which is, would you go so far as to argue that lawyers who represented those polluters in the most specific and intense ways, if they left, and not because they had difficulties, just they were retiring and then wanted to come into practice, would you say that no other law firm should hire them? Would you take it to that level? Yes,
depending on the context of the lawyers. I am the millennial on the panel, so I'm going to be a little bit controversial and say this. So to your earlier question about should lawyers hold other lawyers accountable, Yes, 100%. Lawyers hold a lot of power in society, right? Lawyers, I think we have a special place, for better and for worse. I am very skeptical of the way in which law brings social change. I look at the Supreme Court right now, at least progressive social change, right? So that's kind of where I'm coming from. My legal training has occurred in a period of 3 years where like the legitimacy of our highest court has been completely questioned, right? So that's kind of where I'm coming from. And so when we think about accountability and what that means in practical terms for people who, served in prior administrations and legally justify things like torture, I just have a hard time thinking that that by acknowledging their wrongs and recognizing what they've done, they can now sit in a really prestigious and powerful position at one of the most elite universities in this country, right? So I have personally an issue with that. Why? Because what I'm not saying people shouldn't be able to get employed or shouldn't be able to meet their like human rights and shelter, all that stuff. We're talking about people who are incredibly powerful, incredibly wealthy. And I think that's where the analysis requires like some critical thinking, some critical perspectives. Like it's not just that they should be allowed to exercise a profession because they've acknowledged what they did wrong or didn't. I think, again, in many cases, like they're continuing to exert power. Like I think a Harvard law professor exerts a lot of power in ways, in different ways, in smaller ways, larger ways. They, public opinion continues, I'm sure, to like invite, and I'm talking this particular case, but, continue to invite the professor to speak, on issues, maybe like even testify in front of Congress. There's just ways in which we hold power. And I think denying that is just hypocritical in my opinion. And so I think that's why the calculus is different than, from an average person who, when one of us commits a harm to another person, like what do we owe to each other, right? Like I think that's why the analysis changes for me, because we're talking about powerful people, mostly men, mostly white men, right? So again, like there's different axes which we have to, I think, apply. I will give you an example of, recently there's been this pushback against Jennifer Reardon, and I don't know if I'm pronouncing her name right. So she's a former Trump judicial nominee. She's a GOP donor, and she was one of the corporate lawyers at Gibson Dunn, who has essentially helped target human rights lawyer Stephen Donziger for his representation of communities in Ecuador affected by Chevron's oil spill. If you haven't heard of that case, look into it. It's pretty egregious. I won't go into the details, but I do think there's a role for us as lawyers, law students, whatever you want, to push against this sort of thing where like people, I think, can play key roles in particularly egregious cases. Would I feel the same about someone who maybe did some transactional work, for a smaller fossil fuel firm that is also not undermining indigenous sovereignty the way Gibson Dunn is and has and is being critiqued for? Again, I just think there's particular cases. Gibson Dunn, you can go to our website. There's many ways in which they can be critiqued. I don't think that can be the same, is the same for partners and associates at other firms. So that's one example where I'm like, no, right? But there's not a bright line, as I said.
Great, thank you very much. I'm going to take a couple of questions from the chat. I'll read them out loud. And people, anyone else who wants to add a question in there, I definitely still have some more questions if we have time, but I don't want to monopolize. So here's a question from Larry Hellman. Might a wise firm look ahead to the probable inevitable end of the fossil fuel industry and begin backing away from fossil fuel clients and begin seeking to replace them as clients and seeking a PR pat on the back in the process? Brad, that wouldn't count as an exercise in moral accountability, would it? But would it be better than the status quo? And you can answer, but Camila, I'm curious to hear your response as well.
So moral accountability raises the question of what are moral reasons, and moral reasons are conventionally distinguished from prudential reasons, and the desire to score a public relations coup and get out ahead of evolving trends in the market is just prudential. And good on you if they do that. I mean, I'm not saying that lawyers should, law firms should commit professional suicide, but they're not entitled to a lot of moral praise for this either. One thing I'm talking about in the book that I'm working on are what are mechanisms of accountability and just kind of ordinary morality, kind of background morality, and praise and blame is part of it. What are the lawyers we hold up as exemplars and go, this is a good lawyer? They're often lawyers who represent underserved communities or unpopular causes. Who is a lawyer we go, boo? And a law firm that just gets out ahead of changes in the market, it's not going to get a lot of moral praise. They might be financially successful and good for them, but that's not a moral consideration. That's just prudential, just a good management, and that's fine. I'm not meaning to exclude good management, but that's not the sort of thing that counts as a response to a demand for moral justification.
I'll say that I think we get this question a lot, and I think the question's also raised in the advertisement industry context, right? Where there's also this pushback against advertising industry firms that are working for fossil fuel companies. And the question is like, okay, well, what if they're transitioning to a just transition? What if they're investing or like helping, further take us to renewable energy? And I think I'm very skeptical of that claim. First, because like just looking at like, again, top fossil fuel companies, like they're not really investing in a renewable transition like they say they are. And I think just this past week there was this like huge pushback against Exxon for some of its campaigns, like I think greenwashing campaigns. And so I think if this were the companies that were actually leading a just transition towards a climate like health sustainable future, I would feel very differently about making these arguments. But the reality is that the same companies have deceived the public for decades, and so the track record is really bad. And to trust them that just by shifting some of their practices and investing in renewable energy, that it's all good. I just feel quite skeptical of that claim. Yeah, so I'll leave it at
that. Margaret Raymond comments and then asks, I think lawyers often justify their less than palatable work by saying that in the room with the clients, they are advocating for better behavior or choices. I mean, that's something we hear a lot, right? That by representing clients who are bad actors in some way, we have the opportunity to steer them better, steer them away from bad acts. So Margaret Raymond said, is that real? Or is there a way that lawyers can hold themselves accountable in that regard? Brad, you want to take that first?
Yeah, I read that in the chat and thought that was a great observation and a great question. And look, sincerity is a part of ethics too. And so it would be something that one could criticize a lawyer for being insincere about what about saying they do one thing and doing another. And I know these conversations are hard. Actually, when I was an associate at a law firm, we had to have a really hard conversation with the client about something they were doing, which was perfectly legally permissible, but morally kind of crummy. And the partner and I working on the case really sort of steeled ourselves to have the conversation. And the client ended up saying, yeah, you're right, which kind of surprised me. But I don't pretend these are easy conversations. And I understand there's a temptation to say, oh yeah, we really tried hard, worked on the client to get them to change. And you can say that and not do it. But to this idea, and Camila raised it earlier, what constitutes sufficient atonement or whatever, it has to be a good faith effort. You're not always going to be successful. And, I would go back to my fiduciary principle. Sometimes the client is the principal, you're the agent. There's a division of moral labor here. They get to make the call, you carry it out. But if you're going to try to, rest easy at night saying, I really did try to change my client's behavior, then you really do have to try to change your client's behavior.
I'll just say briefly, I think that's especially true, in like the corporate like responsibility sector, or like when, I remember in admin law, there were all these examples of like law firms that actually like their job is to help their clients comply with the law, not in like a necessarily bad faith way, but like in a, hey, we want you to like apply the law and not get fined by the regulator, et cetera, et cetera. And I think in many of those cases, like what Margaret's raising is totally true. Like I think there's, like I want people with strong morals to like be representing those clients and advising them to do the right thing, quote unquote. But again, I think depends on who you're talking. Like if your client's main business is to like burn fossil fuels, which cause climate change, I just don't think there's such a thing as like, oh, maybe you could burn less. Like what I just think that the same analogy doesn't apply.
Mm-hmm. Fred Klein asks, hi, Fred. Isn't this the same issue as the physician who treats a patient who is a criminal or at least immoral? Isn't this a question of lawyer marketing and not really ethics? Julian, you want to give that one a shot?
Okay, I don't know if I have a whole lot to say about this. I mean, I think that it's not, the analogy is not quite there, I think, because, these, I think the client is seeking a service, right? I think just to step back a second, I think you're right. It's not about ethics in the professional responsibility code of conduct sense. I think we established that. But the question is, with respect to the lawyer's personal ethics or the institutional ethics of the lawyer's firm, that's really what we're wrestling with here. And I think that's a harder one. I think it's not just marketing, although I think I agree with you that a lot of it is marketing. But I think it's also it's just like a business that claims to have value. It's like Patagonia, right? This is part of their marketing, that they want you to know that they contribute to environmental causes. But it's also marketing. This is part of their brand. This is how they encourage you to hire them. I think that's what's going on here with law firms as well. But I think there's also with law, the question for me has always been, are lawyers somehow different than, conceding that we have to fulfill our professional responsibility? Does that give us any sort of special shield against criticism or a special duty to make criticisms? And I think there's just a lot of confusion over whether that's the case. I think as lawyers continue, especially the larger law firms, continue to promote and sell themselves, and maybe this is just marketing, as doing more than just being profit-seeking enterprises, then I think there's a fair question as to how seriously we should take them in those contexts. And so if you're going to put yourself out there, then you have to take you have to take the criticism. And maybe it's just going to be a hit to your reputation. And one thing I was thinking about here is, if you look at this from an economist's perspective, who has the leverage on the law firms, right? If we're not talking about moral, law students from elite law schools like Camila maybe have leverage on law firms. Employees have leverage on law firms, but maybe their external criticism has leverage on the public reputation law firms. So that could be maybe what's really going on, and maybe there's no. But I do think the moral dilemma needs to be explored to figure out the validity of the criticism, how seriously we should take the criticism of the law firms or lawyers who are taking on these cases.
Do any of the three of you, in your experience with law firms, have a feeling that it is something that law firms regularly do, which is to say, how do we hold ourselves accountable? Can we justify representing this client? Or is it mostly all about the money? Not to be cynical. And I think that's a little bit what Fred's getting at with this. Is this just a question of lawyer marketing too?
I mean, I'll just say quickly on, go ahead.
Go ahead. Oh, no, sorry, I didn't mean to. I guess in Zoom land now, just clicking the mute button is like raising your hand. I was just going to point out that I'm in the middle of reviewing a new book by Mitt Regan and Lisa Rohrer called Big Law, which is based on a ton of interviews they did with partners at a bunch of AmLaw 100 law firms. And, I'm not a social scientist, so I don't know how reliable this interview-based data is, but one of their findings is that law firms think about this a lot, and not just from the money point of view. Now, on the one hand, the concern about money and recruiting and will law students come join our firm or whatever could be all to the good, because one of the mechanisms for ensuring accountability are these social criticism and shunning and ostracizing and things like that. So, I mean, Camila had a great line that I'm appropriating from her in one of our preparatory discussions, where she said, the point of law students for climate accountability is to reduce the social capital of law firms. And, nobody wants to be the next pariah industry and the next, tobacco industry or something. So when you, meet someone new, you say, what do you do? I work for RJ Reynolds, and everyone goes, oh my God. So that's appropriate, right? That's an appropriate use of cynicism to motivate compliance with ethical requirements. But I think there's a non-cynical aspect to law firm management, which is that law firm, and the book's argument is that law firms need to guarantee an environment in which lawyers believe that they're contributing to the realization of a greater whole. Otherwise, they'll just defect. They'll just cut and run and go to another law firm that pays them more. And so in order to create the human capital that keeps law firms together, law firms have to satisfy monetary and non-monetary needs of their constituents. And one of those non-monetary needs is to believe that you're contributing to a greater cause. I mean, nobody wants to feel like they're a sleaze. I think it's easy to criticize law firms for being nasty, but nobody really wants to go through life feeling like, yeah, I'm a nasty person, but I'm making a lot of money, so what are you going to say to me? People want to believe that they're doing something good, and so law firms do have these conversations. And I understand this can drift into kind of justification, but there's also some sincerity going on there too. And I don't want to make it sound like it's always cynical, because my understanding from the data is that law firm partners do have genuine conversations about the morality of what they're doing and why it's acceptable to do what they do.
Camila, do you have that same faith?
I mean, at this point, I don't think any law firm in this scorecard will hire me, nor I'm seeking employment from them. So it's hard for me to actually, talk from experience. I don't want to be in a firm, and but I will say anecdotally, and again, this brings the question of success and metrics and how do we actually know if we're having an impact. I will say that we've had several law firms reach out to us for different purposes, right? I think there's law firms who are really upset at their score and have an issue with their methodology, which is subjective, like any methodology, and they push back, right? Or they push back against the data we use, all of which has been publicly available, except for one that's, except for transactional work, which is under a license. And I will say there's firms that have gotten excellent grades who want to use that in their campaigns and their promotion materials. So they want to say in their website and their social media accounts that they've received an A, from LCA. So the fact that I think firms are engaging with it shows that it has an impact. Of course, a lot of these discussions are happening behind closed doors. We don't actually know what they think. But anecdotally too, we know that law students who are planning to go to firms have used the scorecard. We've had folks reach out to us and say, for campus interviewing, I decided to not go for any F firms. They, maybe some D's and C's still, but that for me, that's a success. If someone's at least using it as a tool in their selection process, right? So I think it totally depends what you're asking, but I will say that if this wasn't having an impact or there were people who weren't interested, I think this would have gone nowhere. And I think it's actually been the opposite. We've had, again, and not even with, and that's within the legal industry. I think there's people outside the legal industry who have, again, tracked kind of the financial sector and the advertisement sector and have said, wow, this is what we've been expecting and wanting to see from lawyers. So so far, I think it's working, and I think it is in some ways we'll never really know, right? Unless we're inside we're an associate at those firms. But I think so far it seems like it has had an impact.
Great, Robin. Charlotte, I am going to come back to your question about civil versus criminal, but I want to pick up on the law student point because one of our law students here, Rita Osmani, asked a question. She's a social justice fellow here at Hofstra, and she says, at what point can we also shift accountability to the corporations we use for legal resources as well? So, for example, many law schools have joined the #NoTech4ICE campaign that pushes against Westlaw and Lexis being sort of promoted and used at law schools because they have contracts with ICE to provide surveillance information about vulnerable immigrant communities. So she says we shouldn't just hold lawyers accountable here, but we should be pressuring school administrators and corporations, legal services corporations like Lexis to answer to this. Not a question there, but any responses from the panel?
I just wanted to say a couple things quickly. One of them is you may have noticed me frantically typing. That's because I have a book contract to write about this. And so many of the things that have happened have been so excellent that I wanted to take them down as notes. And that question motivated me to make very clear when I'm discussing this, that there is one of the arguments for role morality, I was talking about that earlier, is there's a division of moral labor between principal and an agent, between the client and the lawyer. And the theory of non-accountability, the theory of this idea that lawyers can't be criticized on account of the client's objectives, is that the accountability should rest with the client. That if you don't criticize the lawyer, what you're doing is not dissipating accountability, you're placing it where it belongs, which is on the client principal, not the lawyer agent. The lawyer agent just provides technical expertise to allow the client to do this thing that they've chosen to do, and it's their choice that is the locus of accountability. So I think that's right. Now, everyone's going to say you're letting lawyers off the hook, but I'm not so much trying to do that as just trying to make sure that in this division of moral labor, we don't eliminate accountability for the client's choices. So I'm very much in agreement with you.
Julian, what's your reaction to Hofstra canceling its contracts with LexisNexis Westlaw?
Well, that's interesting. So I think that here I need to sort of think about something that I was thinking about with Camilla's comments too, which is that we have to think about that there's a diversity in views on a lot of these issues. So, for instance, on Camilla's issue, there's a diversity of views, or there are groups that might not agree. There are law firms and law students who might be like, really don't care about climate change, and so that's fine with me, and so I will. And I think that's true for and that's why it's a little hard to generalize again, because it might depend on the particular campaign. So on this one, I'm not going to talk about it too much, except to say that I think we're ultimately we have to address these on the merits. We can't just brush it off as this is not relevant because we're lawyers, right, or the legal profession, or law schools, right? So I think ultimately you do have to attack on the merit. But I think what the insight I'm taking away from Brad's comment is that sometimes on the merits the answer is no, or I don't agree, or I think I'm right and you're wrong, right? And I think what's hard about this, and I think this is something I am a little concerned about, because we do open the door to, I don't know what the term would be, cancel culture for lawyers, right? I guess, or whatever or advocacy or lawyer shaming, is that we have to defend our actions on the merits. I think that's the most important thing, and we have to understand that there's a lot of diversity on what you're going to be attacked for, shamed for, right? So, and so this is going to lead to more division among the profession. This will lead to more arguments. This will lead to, so for every climate change campaign, there'll be, there's the, we have to get out of, we should stop. You can always pick the particular group that you're upset about, that you want to get out. And how do you decide whether we should join this campaign or that campaign? Ultimately, you have to go on the merits, right? What is your, what do you think? Do you agree with the campaign? Not, do I just want to avoid being attacked? But that's really hard to do. And I think this is the road we're heading down. And I think my only take on this ultimately is if corporations and businesses and people in our society are taking this on, law schools should take this on as well and defend their actions on the merits. And that would be true for lawyers and law firms as well.
Yeah, I mean, I feel like if I'm adopting Brad's, I think kind of optimistic view, it's that by having these challenges out there to LexisNexis or to the law school for having those contracts or other issues, you're starting a dialogue that can lead to some level of action where appropriate. So I think I don't know that it necessarily has to further divide the political spectrum, which I feel is a bit where you were going with that. Robin Charlo, professor here. Hi, Robin. As a formal federal defender, we used to cite as our primary justification for representing those accused of abhorrent acts that we were protecting the justice system for all. That is, we make sure everyone has meaningful access and we don't prejudge the proper outcome. Why isn't that also so in the civil context, that we shouldn't be put in the position of prejudging who has access to a system designed to give everyone access to a fair adjudication? Robin is a constitutional law professor here at Hofstra, so she's well aware of the right to counsel in criminal cases. So obviously beyond that, why isn't that also so in civil cases?
So one of my good friends in this field is a New Zealander, and he says, you Americans need the cab rank rule, which they have for barristers in the UK and all lawyers in New Zealand, which is lawyers, in civil and criminal, have to take the next client that comes in the door, like a taxi waiting to take passengers at the airport, no discretion. And he says that would be good because it would focus lawyers on exactly this point, which is that lawyers are primarily institutional actors and their ethics should be understood as fostering access to the goods of, justice or ordering under law, the rule of law, or whatever. I sort of sidestep that in my work when I say, for the most part, lawyers' discretionary decisions not to represent clients don't tend to result in a denial of access to these goods. And Camilla has said many times now, deep-pocketed, powerful clients are not exactly losing access to the goods that are secured by law. So that really isn't a practical consideration, but as a matter of ethical theory, it's worth thinking about. And I take Tim's point seriously about the cab rank rule, which is that if we really did in the US, let's just say the ABA tomorrow adopted the cab rank rule and said you have to take the next client that walks in the door, it might really reorient our thinking about the ethics of the professional role around rule of law, access to justice, and things like that, and not the morality of the client's objectives. So it would shift from that kind of earlier way of thinking about theoretical ethics, which is legal ethics should be about justice, and more about an institutional approach where legal ethics is really about facilitating democratic governance and the rule of law, which I'm kind of sympathetic toward.
Could I make a little comment in reply, if that's okay?
Sure.
Because it relates to how you began the program. I remember the conversation with Monroe Freedman about who he would and wouldn't represent. And I remember him saying that he would not represent a Nazi, for example. That was his one bottom line that he cited more than once in my presence. And then he said, but even there's a proviso, which is that if no one else would, if there was no other access representation, then he would feel he had to take the case. So just a little addendum to what Brad just said.
And some Monroe Freedman context, always appreciated. Okay, from Richard Silverberg. Hey, Rich. I think this one, Camilla, you have to address first. So is the ultimate goal to stop fossil fuel companies from conducting business? I think I know the answer. Or is the goal to prevent fossil fuel companies from obtaining legal counsel? The latter seems unjust and the former impractical. If we achieve either of those goals, haven't we become an immoral, unethical monster, just like the one we're trying to prevent?
I mean, impractical, I think, is to not have a planet on Earth. No, but I mean, in all seriousness, I do think like I folks don't get like the sort of kind of stakes that are here, then it's hard for me to like answer this question in like a genuine way, right? I of course I don't have any illusion, as I said, that tomorrow, the firms are going to drop their clients, or that would be appropriate or ethical in the context of our professional obligations. I will say that I think the science in the last 10, if not 50 years, has told us that there's a clear connection between burning fossil fuels and the climate crisis. And I think, right now we're in a panel organized by Hofstra Law, mostly seen by law students and, lawyers in the US. I'm originally from Colombia. It's a country in South America, incredibly vulnerable to climate change. Most people would have never even dreamt to come to the US. It's a place that, even though it's a middle income country, is still already facing the burden of climate change in a way that I think many of us are not. And so I think for me, at the end of the day, it's a justice question. Like, is it like super practical? Like, perhaps not, but it's not about what's practical or what isn't, or what's legal and what's not. But for me, it's a question of morality, right? It's a question about if we deeply care about human rights and we think that, and everyone in the world deserves a chance to a life, where their human rights are not threatened by the impacts of climate change, I think we need to shift our entire economy, right? And I think that's the challenge of climate change. We're not talking about one company's pollution in one river, not to undermine the impacts of that, but they're very localized. We're talking about a global challenge. And I think it's a global challenge that, like everyone is trying to, from like the Paris Agreement and international law to like, counties and municipalities passing their own like energy efficiency regulation. It's quite a massive one, and it's a structural one. And I don't think this will solve climate change, but I do think this is a piece in the larger puzzle of accountability and a call for justice. And as someone who deeply believes in human rights and climate justice, I think that as law students in one of the richest countries on earth, where lawyers hold incredible power, there's a need for accountability. So I don't know if that answers your question. Again, I'm not saying they don't deserve lawyers. They should have representation. Should it be the fanciest and most prestigious law firms in the country? I don't think so.
Thank you. So we have just a few minutes left. I'd be interested in hearing from each of the panelists on if you can kind of nutshell a message for law students for all of this. And I think, maybe Serena's point in the chat, hi Serena, is a good point in terms of starting off. You don't have to talk about job choices, but she says, as individual actors making job choices, you law students have the opportunity to think about how different legal positions will contribute to your own moral injury, self-worth, and burnout and/or job satisfaction. So, Julian, do you want to start us out? Just in terms of if you have any nutshell messages for law students.
Yeah, I mean, I guess I wanted to sort of, I give advice to law students unsolicited all the time, so why not keep going with this? I think that law students are pretty good at thinking about all the different factors. They get a lot of good advice on, you think about long-term career, not short-term, and things like that. The question is whether to throw your political moral sensibilities into this analysis. And I think for a lot of law students, I think they would not. I think they would look at the quality of life, salary, location, family life, family balance, things that are very personal. The types of issues that Camila is talking about, I think, aren't necessarily at the heart of most law students. And the question, I think, is should they? Would I advise someone to consider it? And I think, this is a wussy answer. It really depends on that person, right? Is it something that you think matters enough to you that it would really impact your ability to sustain your career if you are doing something that you find morally abhorrent or objectionable? And if it's going to be a serious problem for you, then don't go down that road, right? Now, how do you know? And this is where it's hard. I think it's very difficult to make that judgment. And I also want to make the plea for diversity in thinking critically for yourself. And this is what I worry about with the various campaigns. I can see that I like this particular campaign, but I don't like that particular campaign. You have to think seriously about what really matters to you. What do you really want to commit your principles to in terms of committing your career? The most valuable thing you have is your time. You have to be careful in making those judgments. And so I do come down ultimately thinking, yes, you want to think critically about the broader political moral implications of what you're doing as a lawyer. Because this is a big decision and you can't ignore it. At the same time, you have to make an individualized judgment. I am nervous about being swept up with other people's moral judgments as to what is moral or not, rather than your own judgment, which I think is hard to do.
Our Zoom is going to cut off at 2, so I apologize for cutting you off, but I want to give Camila and Brad a chance. Well, Brad, you want to go?
I'll just say something very quick, and it sounds wussy too, but what the heck? I think while I think law students should engage their own moral values and should see themselves as being moral agents in this process, completely agree with that. I don't think there's anything necessarily morally problematic about working within a system that has as its end representing people who disagree within the rule of law. The rule of law is a massively important, morally significant achievement. And I understand this sounds like I'm whitewashing, corporate law firm practice, but it's not all bad. I think there's not necessarily a bad thing about participating in a process that has as its end the orderly resolution of conflict. So, I just don't want people to come away from this thinking that there's this dichotomy between big law firms, bad, public interest lawyers, good. I do think mostly public interest lawyers are good, but that doesn't mean that all what big law firm lawyers do is bad. And there's a kind of fiduciary principle way of understanding the ethics behind that. It's not just that it's legally permissible, but it's ethically a good thing to do. I know that'll get me criticized, but that's okay.
Thanks, Brad. I appreciate it. All right, Camila, you have the last word.
Shockingly, I don't agree with everything that's been said. No, I mean, I think I agree that it's a personal, individual choice. Everyone has different circumstances, and all of those matter. At the end of the day, if we're being trained as lawyers, that means we already have extra 3 years of graduate school, and the ability to exercise that, that power should be done in a responsible way. So I whether that means working at a law firm or not, I don't think that's a yes or no question for me. I know it's a no, but doesn't mean that it's for others. All I'll say is use the scorecard, right? Like if that's something, if climate is something you care about, use it, and then ask questions about it in your interviews. And if you go to work with those firms, like hopefully you can initiate some of those hard discussions within the law firm. So I think there's a role for everyone. I think this is an ecosystem of advocacy. I think people take, I take more radical positions. I don't think everyone has to, but all I'll say is, yeah, use the scorecard if you do end up, wanting to go to a law firm.
Thank you so much. Thank you to all of our panelists, to the terrific questions from the audience. I hope it's given us all a lot to think about. Thank you guys for participating.